Kenya will soon be marking the 5th anniversary since the adoption of the new constitution. But the anniversary comes with a looming possibility of dissolution of parliament should any person move to court to sue parliament for failing to pass key laws. An advocate now says that the High Court may soon get the opportunity to restrict the tendency by politicians of circumventing otherwise binding legal provisions.
On Thursday, the National Assembly took a one-week break to allow members attend the African Region Conference on the Commonwealth Parliamentary Association. The House will be reconvening on August 18th. MPs will only have 10 sittings, including August 27th, to enact 14 key legislations whose 5-year constitutional deadline falls on that date. Some of the pending bills include the 2/3 gender rule, the maximum and minimum acreage bill, community land bill, historical land injustices bill, access to justice bill, the bill to promote representation of marginalized and ethnic minorities in Parliament, and the restructuring of the provincial administration bill.
Why do you think Parliament delayed enacting these laws, yet it had 5 good years to ensure that these laws were in place?
What I have seen our Parliament, even government, does usually is to create a crisis of necessity so that people are compelled to accept even a mediocre bill because we must beat the deadline.
Since the adoption of the new constitution, Parliament has often extended deadlines or rushed bills in the House by reducing days set aside to debate bills through the guillotine process. Some of the bills awaiting enactment are controversial. Because of converging common interests and driven by fear of dissolution of Parliament, lawmakers could invoke Article 261 of the Constitution, gang up and muster the 2/3 of members to extend the deadline.
If we extend those timelines for a year, it is going to get into 2016 at the time the campaigns for the next election will already be heated, and that will muddy the waters and cloud the place so that even these laws may not be passed in the content of the laws will most drastically change because of the political interests related to the next election of 2017.
The Magistrates Court Bill is another critical legislation with the August timeline yet to be enacted. The bill seeks to give original jurisdiction to subordinate courts to hear and determine applications for redress of a denial, violation or infringement of and/or threat to a right of fundamental freedom in the Bill of Rights.
When I look at the number of people who are arraigned before courts with even unconstitutional charges or fatally illegal charges, which even the magistrates can see that there is an important constitutional question, but they have no authority to determine it, then it has got to go to the High Court and bog down the High Court and create what we call backlog of cases. Parliament needs to also urgently, in my view, enact that law provided for under Article 23 to give subordinate courts authority or jurisdiction to determine constitutional questions when they are posed before them.
The subject of the gender rule has been so emotive, with the women holding high expectations that the laws should be in place by August 27th. Do you see a possibility of someone rushing to court should Parliament fail to enact this rule by August 27th?
It is possible that that judgment of Mumbingugi can be used to now petition the Chief Justice to direct the President to dissolve Parliament. It may sound extreme, and if it sounds extreme, Kenyans must learn that it is not right to do what is convenient at all times. Convenience must not be the principal the guiding principle in the development of public